Erez, thanks for having this conversation with me today.
Thank you for having me.
Part of a series of New York City market conversations that we're having, kind of brought on by the adjustments that everybody's making from the coronavirus. And this one I'm excited to have because New York City owners got a great piece of good news last week, which they all need for several reasons. And one thing that business owners from all types need is certainty. And the Regina case appeal came down in owners' favor. So can you just give a brief description of what happened last week and why that's so important and kind of impactful for multifamily owners in New York City?
Sure. So, Peter, again, thanks for having me.
Yep.
The Court of Appeals decision was really quite significant. And just to put it in context, in June of 2019, I'm sure your entire community is very well aware that the legislature passed a sea change of new laws, the HSTPA, and a broad descriptive of that new law was expansion of tenants' rights.
Right.
In particular, with regard to overcharge claims, the exposure for landlords was amplified dramatically.
Right.
Claims went from 4 years to 6 years, and the method of calculating the base date is much more draconian from a landlord's perspective.
Right.
The issue before the Court of Appeals in the Regina case, and there were 3 other companion cases that were decided together, in simple terms, was retroactivity. Would the new formula available under that statute apply to cases before June of last year? And if you just take a big step back, you think about our respective clients who resolved cases over the course of the last decades, and from a business perspective, underwrote a claim, figured out a resolution, and put it to bed. The idea that they would have to revisit that was frankly scary, because you're running a business, you're exposed to a certain claim, you resolve it, and you move on with your business. And now the idea would be potentially you'd have to go back and open that up again under a formula that's much worse for you. So thankfully, and I think correctly, the bench, the Court of Appeals, realized that that could not work. Due process required that the HSTPA applies prospectively, but they determined, and again, I think correctly so, that retroactivity doesn't apply. So that should give everyone from the landlord community some comfort in knowing that those claims that were resolved, things that happened before under the old formula, those are not exposed to the 6-year look back and the method under the HSTPA that goes about calculating these claims, which again is much more draconian than what existed before, which was, as I'm sure you're aware, 4 years, and you were barred from looking at anything beyond 4 years absent fraud.
Right. So the owners operated under one methodology up until June of 2019, and what was in question was now you owners and the whole industry was concerned that you could take a new methodology that came down in June and then apply it to ways business were done previously that would open up owners to all this liability on something that they thought they were following the rules the correct way at that time, and they had no control over. It was basically judging history by today's laws without the benefit of being able to go back in history and change how you conducted yourself back then. So in many ways, it was really unfair to owners, and so now we have that certainty.
Yes.
The biggest thing that we're celebrating, and where we came upon this, is that you would have an owner who wanted to sell a building and a buyer who wanted to buy it, and because there was this question mark of liability, of overcharge liability, And when you spoke about the treble damages and the other calculations, these numbers grew substantially to the point. I mean, we had some extreme cases where because the buildings had loans on them and stuff like this, where the amount of the liability in the worst case scenario was greater than the actual equity in the building. And now in reality, these scenarios most likely wouldn't play out like that. But to a buyer, he would say, hey, look, I'm buying something. I don't want to just buy liability.
Right.
So how do you think it changes things that way from a transaction standpoint? I guess from a seller standpoint of they wanted to sell a building. They didn't have paperwork going back, say, 10 years or 8 years or 6 years. Now this ruling has come down, limited it to four. Does it give more flexibility to those owners now?
I think it does. Look, I still think all the housekeeping issues that sellers and buyers normally look at in a traditional multifamily sale from a legal perspective, the documentary evidence that you need to see to get the parties comfortable, those things are not going away. But what this decision does, I think it permits the parties to a transaction to get some comfort that they can fence in based upon a certain time period, subject to those documentary evidence,
right?
Those items that we would if they have most of those, or if they have all of them, ideally, now you don't have to worry that the calculation is any different than it was all along, because these decisions confirm that, again, before June of 2019, it's the same approach, the 4 years and anything beyond, all the documents that could come into the equation beyond, which is what the new law says, you can't look at those unless there's a situation of fraud. So that's a long way of saying I think that should give the parties an enhanced level of comfort around these themes based upon this decision.
Yeah, well, it's really significant because for the ownership community and the operators, first of all, the time period we're in right now, it's an essential service.
Definitely.
A lot of owners themselves who self-manage their staff, they are putting themselves in many ways in harm's way by keeping these buildings operating, keeping them cleaned, keeping them up and running. And to get, they've had, for so many years now, really, they've had no support politically from the local government. So this is, it's a small win, but it's very symbolic that way. How long?
I think you're actually, to just jump on what you're saying in terms of the symbolism and the timing, it's only been 10 months since these new laws went into effect.
Yeah.
And in terms of the symbolism, I think this is an important topic to consider. This is it's a chip away at a series of statutes that widely expanded. I don't think there's any debate. They widely expanded and enhanced tenant protections. And maybe there's some notion that this moves it closer to parity. And this decision could symbolize more of that to come, perhaps, more moving the needle towards the middle, shifting it, because there were so many things left open by the HSTPA, so many different subjects that seemingly were improper. And here we have now, in April of 2020, 10 months after the statute was passed, the first ruling by the Court of Appeals, the first significant ruling by the Court of Appeals, telling the community, no, this portion, the retroactivity, is unenforceable as a matter of law. So maybe there are more things like that to come. We shall see. Yeah, well, to just begin to minimize the complexity that owners have on their hands of operating these buildings, and also, it's been feeling like for many owners that they're guilty until proven innocent, and so to begin to level that out a little bit is great. I guess, just two last thoughts on this. If you were advising a buyer today, how long do you think it will take for buyers to, this decision came down last week,
How long do you think it will take buyers to become comfortable and actually, just go forward and transact this way, specifically relative to their diligence? Whereas a month ago, we had situations. I mean, I had a transaction on the east side of Manhattan where we were literally at a standstill because we couldn't find documents from 15 years ago.
Right.
We definitely had them from 4 years ago.
Right.
So situations like that transaction will be able to go through now. Do you think buyers are, if you were advising them from a diligence standpoint that, hey, this decision happened, let's take it as it is and go forward?
I think the impact is going to be immediate. Everyone has in the community, all the constituents from your community to my community to the owners, buyers, and sellers, they've all been paying close attention to this. And in 20 years of practice, I think I could tell you with certainty that the New York City multifamily community is very cognizant and very keen, very aware, especially when it comes to decisions that are impactful. So in that regard, I think it will be immediate. Now, again, the same issues from a diligence perspective that you would go through before this decision, those aren't going away. You still need to make sure you have the appropriate backup. But this decision is impactful in terms of minimizing a basket of risk where you didn't know, could this claim be exposed to the new formula? Now that's going away. So in your underwriting and your diligence, you can cross that out, or you can certainly compute something with certainty. And perhaps before the Court of Appeals, you needed, in order to do it the correct way, you had to have all these different contingencies.
Right.
So that's something that I think will have an immediate impact.
Yeah, well, that's great. Great to hear. Great to hear you say that. That's great. One last question for you. When life returns to normal, are you going to shake hands, bow, do an elbow bump, or like a foot tap?
I'm a fan of the fist bump.
Fist bump.
The fist bump. I was always a fan of the fist bump, and I'll continue to be a fan of the fist bump. My feeling is, I think people are going to be asking themselves the very question you just asked, and that'll sort of make its way through society.
Well, we'll have to get Fauci on the next guest and find out if he approves the fist bump. So, Erez,
good idea.
Thanks a lot for your time.
This
was a great win. I know a lot of owners that I speak to are really happy about it. Appreciate you putting some insight, and good luck, and we'll see you soon.
Thanks, Peter. Be well.